Joke's on you, Marty. We're always late somewhere. Welcome. Court Gallery. Well, that was not right. Oh my good Lord. We're live, and I don't know what I'm doing. Other than saying, good evening, ladies and gentlemen. Welcome to the Court Gallery Live. It is 8 p.m. Central Time, 9 p.m. Eastern Time, and we are doing our thing. I've got a day full of court ready for you. We're starting off in Cowlitz County, then we're moving on back into Michigan with Judge Wiggins, and then it looks like we're going back to Washington, and then back to Michigan again, and then into Wisconsin, and back to Washington again. Ladies and gentlemen, we're just going around the country today. It's all good. I encourage you to hang out as long as you can. If you're interested in what we're going to be seeing, check the description for timestamps. Ladies and gentlemen, welcome to the Court Gallery. Getting ready to watch some court. It's getting ready to start right now. Oh, my buddy, Hutch. What's up, dude? Good to see you.
Mr. McIver, and he will present his testimony, and then there will be an opportunity for a very brief rebuttal from the plaintiffs. One thing that's very important to understand is to direct all of your remarks and all of your testimony to me. Don't argue amongst yourselves and don't speak while someone else is speaking. It's very hard for me to understand the testimony if multiple people are talking at the same time, then I can't really hear anybody. The burden of proof in this case is by a preponderance of the evidence. And that's the threshold level of proof that the plaintiff will have to meet in order to prevail. What a preponderance of the evidence means is more likely true than not true. I do see that both sides, it looks like both sides have pre-filed exhibits, and I have not had a chance to review these yet. It's been a very busy morning. So I'm going to go ahead and take a look at the exhibits right now. So the parties can just please stand by for a brief moment. Okay, so I have briefly reviewed the exhibits filed by both parties. I have reviewed the complaint in this matter. And what we're going to do to start off with is I'm going to go ahead and admit, well, first of all, before I admit the documents into evidence, I'd like to ask the plaintiffs, have you had a chance to review the documents provided by the defendant in this case?
We've never gotten anything.
Okay. Did you understand you had an opportunity to come to the court and pick up your copy of the exhibits?
No, we thought it was coming through the mail.
Okay. Well, that's not the way the process works. Mr. McIver, did you have a chance to review the exhibits reviewed by the plaintiff in this case?
I learned that the process works, but you pick it up at the court very last minute. So I had not gotten the chance to review the evidence that they had submitted. Okay.
Well, here's what I think we ought to do is if there's any, we're going to hear testimony, and usually the way these hearings work is most of the decision is based upon what I hear presented in terms of testimony during the hearing. And if there is reference to exhibits that you have not seen, I can go ahead and find the exhibit and read it into the record or explain what it says. But I'm going to admit into evidence both packets of exhibits. I am going to make a finding that both sides had a opportunity to pick up the other side's exhibits, but didn't do that. And so, but it certainly was an opportunity that was available to the parties. So with that, the exhibits, both packets, are admitted into evidence. And I'm going to go ahead and swear you all in to testify. So everyone, please raise your right hand if you're going to be testifying in this case. Okay, do you promise to tell the truth during today's court hearing and proceedings?
Do.
Yes.
Okay, all right, you can put your hands down. Thank you, everyone, for swearing in. And as I mentioned just a moment ago, we'll go ahead and start with plaintiffs. So go ahead and present a summary of your case and why you're seeking $10,000 in damages today.
So our total balance was that we did not receive back from the vet was $13,063.48. We're only seeking a $10,000. That's what Tara had put in herself, cash. And we have all the bills here. You should have them all. I put in $1,098.46 just to start out for the vet could do the first set of.
Well, let's not. And I apologize for interrupting, but let's not focus on the amounts so much and getting into the minutia. Again, I just had an opportunity this morning to the complaint doesn't really have any facts. It just kind of basically says surgery, repair hip, overnight stay, meds, pre and post surgery, overnight stay, IV meds. But where I would really like you to start off in your testimony is to kind of give me background information. What is this case about from a general sense? And then we can kind of narrow in from the general to the specific. But let's start with a general overview first.
That's what you got.
So he came on our property, and my daughter, I've only met him maybe 3 times, less than 15 minutes, and it's been horrible encounters with him. Verbally abusing me with his language. I asked him to leave my property. He has showed up at my grandmother that I took care of, who was
okay. I still think we need to go back. See, this is my very first time. I know all of you on both the plaintiff side and the defendant side have lived through this experience, but this is my very first time, hearing about this matter. So I need some of the history. I kind of need context so that everything fits first. So explain who you are, what your role is in this situation, how the facts played out. That's really what I need to have as some context as we get started here.
Okay, I'm Tara Peterson. I'm the mother of his girlfriend. I've only had 3 little encounters with him, showing up unannounced, unwelcome, asked him to leave after he verbally abused me, told me I should be scared of him, that he was going to take my daughter, which is fine. She's an adult, coming into my grandmother's home, showing up at our house when my daughter was told not to have him on the property. He chose to drive his mother's vehicle down our driveway recklessly. He chose to get out of the vehicle.
Okay. I really
and our dog was
ma'am, I really apologize. I might be confused here. It looks to me like this case has something. I mean, I saw x-rays, I saw vet bills. I'm guessing this has something to do with some sort of veterinary treatment. We really need to kind of go back and start with that. What I see noted is in your complaint is you're asking for money for surgery and overnight stay and IV and meds. And you're telling me about coming to the property and harassing you and whatnot. Let's start with what the underlying facts of this case. Some animal was treated for some reason. What's the meat and potatoes here?
Okay, our dog was hit by him. We took her to the Columbia River veterinary specialist. They told us that they weren't sure what was going to happen. They needed to do x-rays. They did the x-rays. Then they told us they could either euthanize her or cut off a leg or fix the leg. We told them we didn't want to euthanize her or take off the leg. We wanted her to repair the leg. They repaired the leg. They said they would need an overnight stay. They would be giving her medication for the pain, and that they would do other x-rays, which would take over a couple months' time because we had to have time between the post-surgery to get the next set of x-rays. They did another set of x-rays that was already in the cost of all this stuff. We paid upfront all the monies that was owed to them, and then we even borrowed money to pay. They did give us some money back that wasn't used for the dog, which I have that too. So we're pretty much just asking for partial payment of what's total owed.
Okay, so your dog was injured. You brought the dog in for treatment. The veterinary professionals rendered treatment. You paid up front. Looks like in excess of $10,000 you paid up front. Some of that money was refunded because I guess all of the treatment wasn't rendered, and so there was some money that you had paid that was in excess of treatment actually rendered, so that was refunded to you. What went wrong? What's the basis for? I guess it looks like you're wanting your money back. What's the basis for that?
He's the one that hit our dog in our driveway,
Oh, I see.
driving
Okay.
recklessly.
Got it. Got it. Okay. Understood. Ma'am, and now that I kind of have a frame of what happened in this case and what this case is about, please go ahead and provide some of those details that you were explaining earlier.
Okay, so the reason why the dog got hit was, one, he chose to drive recklessly through his mom's vehicle in reverse down our driveway. I asked him to leave because I was not going to take his verbal abuse and the name calling in front of my 3-year-old son. He was asked to leave the property. He chose to run up his murder and leave my property and hit our dog.
All right, anything further from either of the plaintiffs at this time that you'd like to explain?
No, thank you.
I'm good right now.
Okay, great. Well, thank you both for explaining that, and appreciate your patience in terms of kind of getting that organized and laying that out. I understand your claim at this point. At this time, I'd like to turn to Mr. McIver and like to hear from you.
The day started with me and Lily texting each other because the day previously, Tara had told Lily that she was kicked out of the house and that she had a week to get her belongings. So me and Lily are texting back and forth, and I'm like, well, what's the plan? What are we gonna do? And she wants to get out of there. I'm like, all right, I'll be the ride. I'll bring my mom's car. So I drive up to Kelso, Longview, and she wasn't quite ready packing yet. So I had waited at the very top of the hill for a while. And during this time, me and Tara are messaging back and forth.
And is that Tara next to you?
This is Lily.
Lily.
Daughter.
Okay. And Lily, are you're related to the other parties in this case? Are you their daughter?
Yes, Your Honor.
Okay, got it. Okay, go ahead, Mr. McIver.
Me and Tara were messaging back and forth talking about the situation, and towards the end of the conversations, she had said, I would really love to have an adult conversation about this instead of going back and forth with stories that may not be true. And I completely understood because I would love to have a conversation with her because I'm not trying to take her daughter away from her. I was asked if I could help her move out, and of course I'll be there and I'm going to take her word for it. She's an adult. At the end of the day, it's her own decision. And I had backed into the driveway after Lily had told me it was okay to drive up. And I was really careful of the dogs. I had backed in successfully without hitting any dogs and had gotten out, started conversing, and Lily was still packing her things and trying to gather some of her belongings. And me and Tara were talking, and it turned into bickering, and then it went all of a sudden into we're being nice and she's worried about Lily. And then it's back to, oh, you're breaking a family apart, and I've never experienced anything like this before, and trying to, be a robot, like, all right, let's just get her things in the car and get out of here. And I completely own, I should absolutely not have said this to Tara, but she had asked me, do you think that you'll be able to take care of my daughter? And in quote, I say, I'll be able to take care of her better than you ever have. And at that point, she had told me to get off of her property. So
Did you hit the dog?
not yet. I I'm getting to that point.
Okay, go ahead.
So she had told me to get off of the property, and I was like, okay, of course, I'm gonna get off of the property. I don't want to cause any more trouble than I already have. I was standing right next to the driver's side door, so I just open the door, get in, turn the car on, and I start slowly driving forward. And I felt like a speed bump, and I was like, I did not drive over a rock or anything when I backed in, so I stopped. I look out the window and I see the dog limping away. I see Tara facing the complete opposite direction, and then she turns around and is like, "Oh my God, you hit my dog. I'm calling the cops." And I get out of the car and I'm like, "Oh my, I'm so sorry. I had no idea the dog was there." And she's calling the cops, and so I was like, "Okay, best thing for me to do right now is to get off of the property and wait for the police to arrive." And they had arrived, and she had said that she was wanting to press charges against me, and the police had said, dogs get hit all of the time. We can't really do that. And then they let us go. And afterwards, I had been, they had taken the dog to the vet 4 days after this had happened. So I was somewhat confused about that. I had some questions. I had messaged them that I would take care of the veterinary expenses because I was trying my best to mitigate and cause no harm done because it was a complete accident. And days, weeks later go by. We all of a sudden we get this paper and it's saying $11,000 owed. $11,000 491 cent $11,491.60. Sorry. I had messaged and said, that is a crazy amount for a vet bill. I need to see some actual documentation because they had only sent me a picture of the number. So I was very, very confused. I had even messaged the veterinary surgeon who had performed. I had emailed them and they had said that I needed permission to ask about the procedure from the owners of the dog. And I had asked for permission to maybe dig deeper into that, and I had gotten no response.
So let's talk about the incident itself and how that happened. So I understand you're having a confrontation with with Ms. Pedersen, who's your girlfriend's mother, and there's some interpersonal dynamics going on there, obviously. You were preparing to leave the property, you got into your car, and you ran over the dog, but explain how it is that you didn't see the dog. What, and I understand your testimony that you kind of felt a bump that you hadn't
Yeah.
experienced before, but kind of how did that happen that you didn't notice the dog there, didn't see the dog?
So I was standing right next to the driver's side door, and the dog was laying underneath the back right wheel. So it was underneath the car, underneath, like in front of the wheel. So if I were to drive forward, the dog was right next to the wheel.
So you were driving forward, you weren't backing up.
I had backed into the driveway.
I see.
I drove forward out of the driveway, yes.
I see. Okay, so and the dog was essentially under the front wheel
The back right wheel.
the back right wheel.
Yes, it was
And-
completely out of my visibility.
And but the back right wheel on the side towards the front of the car. So that when you-
Passenger.
right,
Passenger.
but towards the front of the car, so that when you started pulling forward, you hit the dog.
The front tires, the back tire is the one that lifted up.
I understand, but the dog was on the side of the tire closer to the front of the vehicle. It wasn't on
Yes.
the back
Yes.
side of the
I'm so
tire.
sorry about yes.
Yeah,
Yes.
okay. And you just didn't see the dog, and when you started pulling forward, you just didn't
I
know the
just
dog was there.
yeah, I just felt a bump and
Okay.
immediately I had gotten out of the car trying to mitigate.
Okay. Mr. Espinoza and Ms. Pedersen, at this point, as I explained earlier, like to give you an opportunity to respond to the defendant's testimony, and I'd like you to specifically focus in on the issue of fault in terms of we've heard Mr. McIver's explanation as to where the dog was. He didn't notice the dog, really had no way of seeing the dog. You're alleging that it's his fault and that he needs to pay for the vet bills because he was not exercising due care. I mean, that's really the standard that you have to establish is that he wasn't exercising due care, and that's why he's responsible for paying for the injuries. So I'd like you to specifically address that issue if you would.
Okay, I was asleep when all this happened because I just got off a night crew. So I'll let Tara tell you what happened.
So our dog was not laying underneath his vehicle. We have a tree on our property, and our dog walks up and down the driveway, and my son was right there. And the dog walked in front of him when I asked him to leave. He was in anger. He was upset. He was mad. And I had asked him to leave. And we had a dispute how I wasn't going to take his verbal abuse. Just get off my property. I told him a couple times to get off my property. He jumped in his vehicle. He peeled out. Gravel went flying. My dog went underneath his front tire and then under completely around his back tire. My son was right there trying to get the dog from underneath his tire. He would have hit my son if it wasn't for our dog. He just was careless. He was mad. He was pissed off that he was told to leave the property and he wasn't paying attention.
Where was the dog at the time that the vehicle started moving?
In front of his vehicle in our driveway, just walking up the hill as he hit it. Because our yard's like this.
About how far away and kind of what direction from the car was the dog walking? Like, was the dog in motion? Kind of explain the whole incident, how it came together, if you would.
Okay, so our driveway's like this and our hill's like this, kind of slanted from the yard. My son's sandbox is right here, and the dog was walking with my son towards the vehicle, and right in front of him, perfect timing, he had gotten hit. My dog right there.
Okay, so your son and the dog were both close to where Mr. McIver was leaving with the vehicle, and it's
Correct.
your contention that he was leaving it rapidly and carelessly. Is that your testimony?
Yes. And if the dog wasn't there, it would have been my son around his tire.
Okay. And what makes you say that?
Because my son walks with that dog. They are best friends, and the dog is very close to my son. My son at the time was 3 years old. He's a pet lover, and he came from his sandbox, and here's MacGyver in our driveway, and they walked right in front of him. And when I told him to leave, it just happened so fast. There was our dog.
You think you think Mr. MacGyver had a reasonable opportunity to see the dog, and if so, please explain why.
I don't. I think it just was in anger.
No, but do you think that he had had an ability to see the dog?
Yes, anybody would have. If I was upset and you told me to leave the property, I'd be looking around, making sure her 3-year-old son is out of sight and the dogs. There was other dogs outside. We have 4 dogs and they roam. We live on 5 acres of property.
I guess my question is, was the dog far enough away from the car that he would have been able to see the dog before pulling out?
Yes. I would say if you put my car in front of his car, that's plenty of length to see the dog.
Okay. Mr. MacIver, anything to add?
Yes. I would like to specify a little bit more, add some more details that I had left out. As she was yelling at me, after I had said what I had said, I shouldn't have. She was angry. I completely understand. Her son was harmless. He was swinging a little, I think it was a hoe, like a gardening tool, kid-sized, and he was swinging it around, and she had to grab it from him so then he wouldn't hit me. But as she had told me to get off of the property, she was holding hands with her son, and the dog was nowhere to be seen at all.
Well, this is a tough case. And I'll tell you why it's a tough case. I mean, from a legal standpoint, it's actually a very easy case. I mean, the issue is, did Mr. MacIver exercise reasonable care in terms of the operation of his motor vehicle? And if he did not exercise reasonable care, and as a result of his failure to do so, injured the dog, then he's responsible for the costs. The reason why it's tough is because there's no way that what Mr. MacIver is saying can be true, and at the same time, what Ms. Pedersen is saying can be true. I'm in the position where I have to weigh the credibility of the evidence and determine from a factual standpoint what happened. And of course, I wasn't there. But based upon some of the background information that I reviewed in the evidence, police report, Ms. Pedersen's testimony, I find it quite reasonable that Mr. MacIver was probably everybody, at the scene. Well, maybe except for the son and Mr. Espinoza, who wasn't there at all. They might have been calm, but I think probably Ms. Pedersen and Mr. MacIver, and I'm sorry, Lily, is that your name, ma'am? Yeah, and Lily. Probably everybody was pretty excited and in a rather agitated state, given the conflict that was happening, and when that sort of situation exists, it unfortunately is too easy for folks to act more quickly than they otherwise might, and maybe miss things that they otherwise might be able to perceive. And so I am going to find that based upon that Mr. MacIver was negligent in terms of his operation of the motor vehicle. Again, I find that more credible just because of the conflict that was going on at the time. And so I'm going to grant judgment in favor of the plaintiffs in the amount of $10,000. $10,000 is the maximum jurisdictional amount of the small claims court, so I can't award anything beyond that, even though you do claim that there were some additional costs that you had beyond the $10,000. That is the ceiling. So I'm going to grant judgment in favor of the plaintiffs in the amount of $10,000.
All right, this is case number 254712 SD. Appearances, counsel.
Robert Hartzell from Ms. Shattuck, who joins me at the table.
You all may be seated. We are here for a sentencing taken to a high BAC back on November 26th. I have received the assessment from Catholic Human Services along with the mitigation report. Ms. Carey and Mr. Hartel, do either of you have any correction to those documents?
I do not, Your Honor.
I do not.
Elocution, Mr. Hartel?
Yes, thank you, Your Honor. We are hopeful that the court will consider time served and probation in this matter. My client is aware that she de facto pled to the equivalent of as charged. She is aware that the court does have quite a bit more than just time served as discretion, but I would ask the court to consider a few positive things. She has advised me that she does realize in retrospect that she does have an issue with alcohol. It's reflected in the assessment. She does want to start a Vivitrol. I believe she can start that in the jail, if I understand correctly, and she might be getting that injection later today. She has every intent to continue with, I believe, Dr. Brennan, if I recall correctly, to continue with that treatment. It's only one piece of the overall equation, but she does want to do that. She is obviously educated in a bit of medical herself, if I recall correctly. She has a licensed CNA, even though that's not her main career. I point that out to say that even intelligent people make dumb decisions, and she knows that. In hindsight, she knows, even though it felt justified at the time, helping out a family member, things like that, her blood alcohol was at a level that she should have known was too high. She shouldn't have operated a vehicle. She shouldn't have done the things that she had done. And one of the reasons why she was so motivated to plead essentially as charged, just for context, Your Honor, was she knows she had the issue on bond. As soon as she made that, again, mistake, I want to use the term mistake, that poor decision. She made another poor decision with that. And she realized, I need to own this. I need to admit to the court that I can be responsible. And even back then, I was asking her, are you sure you want to do that? I'm a defense attorney. Maybe we can do something better than that. I didn't necessarily know if we would, but she wanted to take responsibility at that point. She realized that she does have that issue, because even when she knew she was being monitored, even when this medically educated mind knew she was being tested, that slip still happened. That's one of the reasons why she needs that Vivitrol, why she's smart enough now to take those proper steps. And I do believe with the proper assistance from her doctors, now that she knows she's past the coping mechanisms, is what I'm trying to say. I might not be phrasing it perfectly, but we all have the coping mechanisms. It's sometimes easier to see them in other people than ourselves. And she realizes that now. And if given the opportunity to be on probation with time served, I don't doubt that she'll do well on it. And she's consciously aware that if she had any issues on it, she'd be right back here. And I don't doubt that people would be asking for more in jail. So I would ask the court to give her that opportunity to prove not only to herself, but to the court, despite these bad decisions, she won't make them again. Thank you.
Mr. Harsell, I have a question on the mitigation report.
Yes.
And that's on the second page, the paragraph right above Roman numeral 3, that Roman numeral 3 is education and employment history. But the last sentence of that paragraph above it says that she previously struggled with alcoholism, but has maintained sobriety for the past 15 years. But in 22, she had a disorderly drunken, and 17 and operating while visibly impaired. So can you explain that to me?
Yes, just a moment.
Oh, I'm sorry. Thank you, Ms. Carey. Thank you. I apologize. That's referring to the aunt.
Oh, okay.
I am sorry about that. Thank you, Ms. Carey. All right. Ms. Carey, any allocution?
You and I do this a little bit differently. I don't think these are dumb decisions or bad decisions. I think it's a problem. I think her history is a problem. I do have concerns in the substance use assessment where she reported that when the police administered a PBT, her BAC was a 0.14. When in fact the police report says the PBT was a 0.223, and her blood alcohol from the blood test was a 0.264. So I am wondering if the assessment would be different. But again, it says there's an issue, but it doesn't give us at what level the issue is. And I'm wondering, had they had that information, that would have changed this.
I have found with this assessor, there's usually not a level put in there.
Well, I think that's problematic, but I still question whether recommendations or the assessment would have been the same if they had that information, because the difference between a 0.14 and a 0.264 is frankly a lot. And this is her second drunk driving, although the other one was in 2017, and then noticed in 2022 she did have the domestic violence that was fled to a disorderly person drunk. So clearly alcohol has been an issue, and an ongoing issue for a while, which is why I don't think this was a dumb decision. And I'm sure it was difficult for her husband to call the police on her, but he did the right thing. She went to pick up their daughter from work at Culver's. So thank goodness she was prevented from driving their daughter in the car. So I am going to ask the court to do a 90-day jail sentence with 24 months of probation. Thank you.
Thank you. Ms. Shattuck, you have the right to address the court prior to sentencing. Is there anything you'd like me to know?
No, sir.
So, I mean, obviously, you know you have an issue. You went to treatment back in March. Now I'm starting to second guess my notes. So how much sobriety did you have between March and the date of this event?
I've been sober all year. So only been since August that I've had issues with my whole job situation right now.
So were you sober before you went to treatment in March, or do you mean after you got out of treatment in
After.
March? Okay, and was it in March you got out?
Yep.
Was it a 30-day?
30 days.
All right. So, you know, Ms. Carey's pointed out that normally we see in these assessments that there's levels of substance use disorder, meaning there's no issue, then there's mild, moderate, and severe. For whatever reason, this particular assessor, very rarely will I see her use a level, which is kind of detrimental to the court because then we're left guessing. But based on your self-reporting, the fact that you've already gone to treatment, and the amount of alcohol that you've reported to consume, which was up to roughly a fifth every 2 to 3 days, I have no doubt, and I'm confident in assuming that it's a severe disorder. You started drinking when you were roughly 20, right?
Yes.
All right. And I know you're planning on doing the Vivitrol shots. What are your thoughts on that?
I think it's a good idea, but I really do want to go and stop. I'm willing to try anything and not keep living like this.
Was that medical assisted treatment discussed with you back when you were in treatment back in March?
It was, I couldn't afford it there.
Okay. But you think you can afford it now, or you've got a plan in place to try to help you with that?
Yeah.
All right. And if I recall correctly, I know we had the probation violation. You had, I'm sorry, bond violation. And that was, yeah, right. You had consumed a shooter back on November 17th. Was that out of necessity, so to speak?
No, I just obviously was not thinking.
Have you had the opportunity to review the assessment?
Yes, sir.
What are your thoughts on it?
Sounds pretty accurate to me.
Were you placed on probation back in your last drunk driving case? Back in 17?
Yes.
Did you complete that probation successfully? Do you remember what you had to do for probation then?
Community service, the driving class.
Anything else you'd like me to know? So the court starts off with the presumption in these cases that there's no jail, no probation. However, that's a rebuttable presumption. And I think in this particular case, there's enough grounds to rebut that presumption. First of all, there's a prior drunk driving in the defendant's past. Second of all, she tests positive, or she tests for a substance use disorder, although we don't know the level. She's gone to treatment and then finds herself just a few months afterwards in the condition that she was in at .264, going to pick up her daughter. Then we also had the bond violation where she consumed alcohol after being placed on bond. She has served a total of 24 days so far based on the bond, more so with the bond violation. But I do find there are probable or reasonable grounds to place a defendant on a period of probation. I am going to place her on a period of probation for 24 months. During that period of time, you're not to violate any law. Report is ordered, not leave the state without the consent of your probation officer. You must keep your contact and employment information current. You are eligible for early release. So if you've done everything that we ask you to do at the halfway mark, you are able to get off at the 12-month mark. Now, if something happens that that your probation officer doesn't think you should be released, but you think you should, you can file a petition on your own and ask the court to make that determination. I know you've taken it before, but I'm going to order it again, and that's the alcohol highway safety education class and the victim impact panel. No alcohol, no illegal drugs, including recreational marijuana, and you'll be subject to testing pursuant to your probation officer. Now, let me ask you, it's been a while, you've been in jail for some time. Do you think you're going to be able to stay off alcohol? I know you're planning on the shot.
Yes.
Do you want random testings, or do you think a daily alcohol test is going to help you stay off for a little bit? And the daily alcohol test would be a remote machine you have with you and blow in at certain times.
Yeah, I'll go ahead and do the daily testing.
All right. I am going to order 30 days of daily alcohol testing. I want you to follow the substance use assessment recommendations. This is a second, so I am going to order you into some sort of recovery program. Counseling pursuant to your probation officer. Alcohol counseling. Also going to order that any additional counseling that your probation officer or programming that your probation officer feels is appropriate. There is a $75 Crime Victims' Rights Fund fee, a $50 state minimum fee, a $200 fine, $150 court costs, $150 attorney fee. I'm only going to charge you for half the probation, which is $360. If something happens, you stay longer than that 12 months, you'll be required to pay the monthly probation fee. Ms. Carey, are the reimbursements requested?
Yes, to the Webster County Sheriff and to the prosecution.
You said this was a blood draw, correct?
Correct.
So $300 to the Sheriff's Department and $100 to the prosecutor. In certain cases, the law allows recoupment for some of the costs of prosecuting these cases, and drunk driving's happen to be one of those, so that's what those two charges are for. There is 24 days jail with 24 days credit. Ms. Shattuck, any balance that remains unpaid for more than 56 days will have a 20% penalty assessed to that. And even though I have sentenced you to time served, it is a period of incarceration. So if you decided that you wanted to appeal that decision and could not afford an attorney to assist you, you have 14 days from today's date to request the appointment of an attorney. Do you have any questions for me about your sentence?
No, sir.
I'm not ordering community service work like you had last time because I want the focus to be on you this time and helping you get the tools and everything that you need to hopefully get you out of this cycle that you're in. At some point, you'll be released from the jail today. If there's still time, I need you to come over to the district court probation office and get signed up for probation. If not, you'll have to do that first thing in the morning. All right? Good luck.
All right, something is going on with Zoom where I'm logged onto my computer and it's not letting me go back into the main room. So now I'm on a coworker's laptop, but we are ready to go.
Excellent. Okay, Ms. Arnold, who do we have with us here from the Pierce County Jail?
Raheem, can you put your volume on?
Ms.
One
Arnold,
second.
can you hear me? Are you able to hear me, Ms. Arnold?
Here we go. We got some sound. All right. Yes, I am. This is Shane McDougal, case number 24L0642. This is a pretrial 2. First off, I would like to request that we get reappointed to his matter because there was a failure to appear back in November of 2024. I have rescreened him and do believe that he qualifies without a promissory note.
Thank you. And are you going to be submitting that screening sheet after today's hearing?
Yes, Your Honor.
Excellent. Based upon that record, the court is going to reappoint the Horwath offices to represent Mr. McDougal in this matter. The court will order the execution of a promissory note that is subject to waiver upon the court's review of the eligibility screening sheet once that has been filed by Ms. Arnold on behalf of Mr. McDougal. Ms. Arnold, how would you like to proceed today?
Yes, Your Honor. Defense would like to take up conditions of release and request a PR release today. Mr. McDougal has been going through some unfortunate things in terms of his housing. His housing is currently, his home is currently in impoundment, and his dog was taken to the Humane Society. And so he did have court yesterday in TMC, and they released him. And so we're requesting that he be released in this case too, so he's able to get his dog from the Humane Society and take action to stop his home from being in impoundment. He does live in Tacoma, and he can take public transportation to get to court. We're asking for one time to be able to reappear. I understand that he was on bench warrant status for a bit now, but we've gone over the importance of him showing up to court. We just hope that the court can consider his predicament. Thank you.
Thank you. So you were asking for a continuance of today's pretrial conference?
Yes, Your Honor, and having an out of custody pretrial date. Thank you. I can upload that.
Let me hear from the prosecution. Mr. Graham, what is the prosecution's position concerning that request?
Your Honor, prosecution objects to the release of Mr. McDougal at this time. A review of this particular case, Your Honor, Mr. McDougall was originally not appeared at the original arraignment planned back in April of 2024, failed to appear. Court issued a warrant for his arrest. He was booked into the Pierce County Jail at that point in August of 2024, where bail was set. Mr. McDougall posted bond, and the matter was reset for an out of custody pretrial. He appeared via 3.4 in October, then failed to appear in November. Court then issued a warrant as a result for that failure to appear. He requested to quash the warrant and then failed to appear at the warrant quash. And that was in March of this year. And so now the warrant got served and he's been booked into the Pierce County Jail as of the 7th of this month, and is here before the court now. Your Honor, he's repeatedly shown the court that he's not going to appear, especially in this case alone, not necessarily looking at his overall criminal history, which does have a number of cases of prior warrant activity. And most of them, it looks like Pierce District Court had a couple of cases with warrant activity, and we did as well back on a 2020 DUI amended to a reckless driving. So Mr. McDougall's shown the court that he doesn't appear when ordered by this court. And so for that reason, I would request that the court continue to hold him on bail, but we do not object to a short continuance.
Is Arnold any response?
Your Honor, I understand that his history is causing the court concern. However, given his very individual circumstance right now and the fact that if he loses the two things that are most important to him, it's really going to have a long-lasting effect on him. We request the court to just let him appear out of custody, given one more opportunity to at least secure his loved one, his dog.
Give me 1 second, please.
Thank you.
Mr. Graham's record is, I believe, accurate based upon my review of the docket in this matter. Mr. McDougall has certainly given the court reason to conclude based on past performance that he is not going to appear. However, the court is also reviewing his criminal history, which is fairly limited. And I do see that Mr. McDougall, it appeared before the Pierce County District Court. Looks like Judge Padula, I believe at some point earlier this week, and she has given him the opportunity to be released from custody to appear. Looks like, Mr. McDougall, you're scheduled to appear back before Judge Padula on Monday.
Yes, sir.
8:45 a.m. I'm going to give you the same opportunity, Mr. McDougall. I certainly hope I don't regret this. The prosecution has made a pretty strong argument for holding you in custody. I'm going to err on the side of giving you one last opportunity to handle this case out of custody. But I'm going to want to see you pretty quickly. Ms. Arnold, is there any objection from the defense? And I should ask Mr. Graham this as well, or from the prosecution. I'd like to see Mr. McDougall pretty soon, given the age of this case. I'm out I'm away from the court all of next week, and I'll have a pro tem, but I would prefer to see Mr. McDougall myself. So I'd like to set him for a pretrial conference at 2 p.m. on Tuesday, December 23rd. Is there any objection from either party?
Yeah.
No, Your Honor.
Mr. McDougall, I'm going to go ahead and release you on your personal recognizance on a number of conditions, and I'm going to go ahead and review those with you right now. First of all, I'm going to see you back here in person and on time on December 23rd. That is a Tuesday at 2 p.m. here at the Lakewood Municipal Court in the city of Lakewood. We're attached to City Hall. We're across the street from the Lakewood Town Center. I want to make sure you know exactly where we are. The other conditions that I'm going to impose upon you are as follows. You are to remain in contact with your attorney. Ms. Arnold's law firm represents you. Their contact information will appear on the paperwork that you will be provided by the officers following your hearing today prior to your release this afternoon. Please make sure that you are remaining in contact with your attorneys. If Ms. Arnold does not already have a good telephone number for you or email address for you, a good way for her to reach you, upon your release, please give them a call and make sure they've got that information so that you have a way to reach them and they have a way to reach you, okay? Court is also going to order that you have no criminal law violations, that you update this court of any change in your mailing address. You are, let me take a look here. I believe you are presently subject to a no contact order that was issued by the Pierce County District Court. Mr. McDougall, you are to abide by that no contact order, okay? Or to sign that order. Mr. McDougall, unless something else is holding you, you should be released later on this afternoon or this evening. You've got a court appearance on Monday, this coming Monday, in Pierce County District Court at 8:45 a.m. You need to be at that hearing in person and on time. And then you've got a hearing in this matter on Tuesday, December 23rd at 2 p.m. in the afternoon. Likewise, you need to be here in person and on time for that hearing. Mr. McDougall, do you have any questions at all about the court's conditions that have been imposed upon you at this time?
No, Your Honor.
All right. We'll see you back here on Tuesday, the 23rd at 2 p.m., sir. You can go ahead and let the officer know that your hearing is done.
Okay, so we are on the record in the matter of the Dorian Jones, 25578. Counsel, your appearance, please.
Your Honor, for the record, John Goldport, P 30758, on behalf of Mr. Jones. Mr. Jones? Please put your name on the record.
Dorian Jones. All right, thank you. And today is the date scheduled for probation violation, and we have an individual here that's set to testify, Michelle Zisnar, and counsel.
Your Honor, for the record, as I said, John Goldport, we are ready to proceed. Mr. Jones understands he has a right to a hearing in this particular matter, and at this time he wishes to avail himself of that opportunity. Is that correct, sir? Yes, I do.
You want to enter into a plea?
No.
No, you want to hold the hearing?
We're holding the
Right,
hearing, yes.
okay. All right, so, all right, and Ms. Zisner, if you can, well, we need the prosecutor.
She's listening, she'll be in.
Okay. Madam Prosecutor?
I'll reach on over.
Okay, thank you. Well, Mr. Kuzmiak, I'm sorry.
One of us, Your Honor.
Okay,
Good morning, Your Honor. Thomas Kuzmiak, people say why not?
all right, thank you. And your witness from Aver Health is also present on Zoom. And so I can have her place her name on the record as well. Ms. Zisnar?
Correct.
Can you please state and spell your first and last names for the record, please?
Michelle Zisnarski,
Can you please spell your first and last names for the record, please?
Michelle, Zisnarski, Zysnarski.
Okay, thank you. Can you please start your video? Thank you. Okay. And Mr. Kuzmiak, today's the date scheduled for probation violation for Mr. Jones. And I'm going to, at this point, I'll just swear in the witnesses. I'll swear in Mrs. Znarsky as well as Mr. Jones. I'm not sure if he's going to testify or not, but I'll swear him in now. So if you both please raise your right hands. Do you solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth, Mrs. Znarsky?
Yes.
Okay, and if I just call you Miss Z, I don't mean any disrespect. And Mr. Jones?
Yes.
All right, thank you. Okay, and the people may call their first witness.
Your Honor, we would call to Miss Michelle Zisnarski.
Okay. All right, and you may proceed.
Your Honor, Ms. Zisnarski, could you please state your name and title for the record, please?
Michelle Zisnarski. I work for AverHealth as a supervisor for the collection site.
And do you have personal information regarding this particular matter?
I am a keeper of records for test results for this client.
And have you had the opportunity to review the records?
Yes.
And the records indicate what?
I have test results from 9/18, 9/25, 10/20, 10/31, 11/5, and 11/14. And I do have the certified record for test results for those.
Okay, and those results were a testing for what substance?
Was testing for a urine 5 panel plus ETG.
And what was the results of the tests?
Did you want me to go with the specific dates? I can start.
Yes,
9/18.
if you would, please.
Sure. 9/18. Specific results. Alcohol was negative. Amphetamines was negative. Benzo negative. Positive for cannabinoid. Negative for cocaine. Negative for fentanyl.
We would stipulate as to the other negatives that we are only here because it's a violation alleged to be
Okay.
marijuana.
Okay, so Mr. Kuzmiak, do you also stipulate to that?
Yes, we would, Your Honor.
Okay, so for purposes of testimony, Mrs. Znarsky, you only need to testify as to the positives. Would that be accurate, counsel?
That's right, sir.
All right, thank you.
Just positive for cannabinoid on that day.
Okay. And the next date that the defendant was tested?
Okay, we have September the 25th, the same positive for cannabinoid that day.
The next date?
October the 22nd, the same positive for cannabinoid.
I'm going to object to the October 20 date. That is not one of the basis for this violation.
Okay.
Well, you can object to it, I mean, but that's her testimony.
I understand, Your Honor.
Okay, and then
It may not be listed as a date for a violation, but then that's her testimony. If you don't want this court to take that into consideration in determining whether your client's guilty or not guilty of a violation, we can address that later, but this is the testimony. Okay.
And the next date that there was a test?
October the 29th, same cannabinoid. The next date that I have is 11/5, positive for cannabinoid, and then the last one is 11/14, positive for cannabinoid.
Your Honor, I have no further questions.
Okay, Mr. Goldpaw?
Excuse me. Do you mind if I call you Mrs. Z as well?
No, I don't mind.
Thank you very much. Mrs. Z, you are the keeper of the records, is that correct?
Yes,
And you have testified that your records indicate that on on the September 18th of 2025, there was a positive test for marijuana. Is that correct?
yes.
What was the amount at that point in time?
I show on September the 18th, the level was 97 nanograms per milliliter.
What does that indicate? Let me rephrase that. You didn't take part in the collection of the specimen, did you?
No, this was collected by the collector on site at our Dearborn site.
Right. And I believe we asked for him,
I'm sorry?
is he on as well? Because I believe we asked for him as well.
We only have Ms. Z is the only one that I know of that's here.
And other than reviewing these records, did you have any other involvement in these proceedings?
No, I am a site supervisor and I have access to his test history. I wasn't on site for these collections.
I understand you weren't on site for the collection. In fact, where are you located today?
I'm in Madison Heights.
Oh, that's nice. Okay. So you're at the collection facility today.
Yes.
This was collected in Madison Heights.
No, this particular one was collected in Dearborn.
Okay, thank you.
I'm sorry, does anybody know the name of the individual that you're asking about regarding the collection person?
No, Your Honor. All I know is from my notes when we were here the last time that we requested the testing facility as well as the lab present.
Well, the note from Ms. Shaw says emailed Ever Health regarding something and test facility person next hearing. So I don't know.
I'm sorry, could you repeat that, Your Honor?
She requested both, so I don't know. We can go off record to see who the other individual is, to see if we have two people in the waiting room, so we can see if one of those individuals.
I think that would be important.
Okay, let's go off the record for a moment.
So how many?
Okay, Ms. Robertson? Ms. Robertson? Please unmute.
Yes, can you hear me?
I can. In what manner are you here for?
I'm here to discuss my ticket that I got.
Okay, she's not here to testify.
No.
Mr. Fields? Mr. Fields? Mr. Fields? Mr. Fields? I don't see a Fields on our docket, do you?
Does not appear to be on the docket, Your Honor.
No, so I'm not sure if he's supposed to be here to testify in this regard or not. Mr. Fields? Okay, well, I just removed him because he didn't respond. Okay. We're back on the record. Counsel, you may continue.
Yeah, Your Honor, so I guess we don't have whoever the other individual is, and that's one of the individuals that we will need.
Okay, well, for right now, I just need you to continue with your cross-examination of Ms. Zanarski.
Okay. I'm sorry, Ms. C.
Yeah.
So the only contact or involvement you have is to collect the data and review the file, correct?
I am a supervisor for the collection site, so I do oversee the collection process for various sites.
Okay. Would it be a fair statement, Ms. Z, that you do not have any independent recollection of the proceedings that occurred during the collection? Is that correct? Of this particular matter?
We follow the same process for collections, but not this specific one. I was not present for this specific.
And so as part of your records, do you have previous test results from prior to the 18th of September?
I do have a result from the before. Oh, I'm sorry. No, I don't. I'm sorry.
So what you have done, and I won't say this in derogatory sense, is when the results are verified, you notify the probation office that there's been a positive test for, in this case, marijuana, correct?
It's electronic and a report is generated and it is shared with the referring party.
Okay. And have you seen in your experience where, for example, the test on the September 18th was tested positive for marijuana, and it was 97 nanograms per milligram. Is that correct?
Yes, that's what the report says. Yeah. Mm-hmm.
Right. That's what the report says.
Mm-hmm.
And
is that yes?
Yes.
Okay.
And the one, you do not have the results prior to that, do you?
No, they are shipped to the lab.
Pardon?
No, they are shipped. They're sent out and reported. Correct.
So if he tested prior to the 18th, then you don't have the results of that test there today, do you?
I don't have any records of tests prior to the 18th.
And then I think you testified that you did have some test results from the 25th. Is that correct?
Yes.
And what were those results?
Positive for cannabinoid, and it's 822 nanograms per milliliter.
Okay. That's quite a jump, isn't it?
Yes. I'm not the toxicologist. I can't testify on part of the lab. I can't really interpret the results, but I just handle the collection part.
And don't take this the wrong way. So you're here to tell us that you reviewed the reports, and reports show this is 97, and the next one is 822, less than a week later. Is that correct?
That's what it came up. The cutoff level is 50, and it came up as 822. I can't interpret results, though. That would be the toxicologist.
Now, you have the results that you testified that there was results from October 20th, 25. Is that correct?
I have the October the 20th, yes, correct.
Okay, and that result was 94, is that correct?
Yes,
So we've gone from 97 according to your records to 822 in 1 week. And then we've dropped from 822 to 94 in 3 weeks. Is that correct by your calculations?
that's what the report says.
That's what the report says. You have no, your job is not to interpret what may or may not have happened as to whether or not tests were bad or things like that, but just that's what the report says, correct?
Correct.
And similarly, you have a report for October 29th. Is that correct?
Yes,
Approximately 9 days after the 20th, and those results were 99. Is that correct?
yes,
Again, you have nothing to contribute as to the validity of those tests, only that's what the tests were, correct?
correct.
And then we have another one on the which is 94, correct? That's November 5th, excuse me, approximately 3 days later, 4 days later.
Mhm.
Yes,
Yes,
again, there's the drop. Is that correct?
the one
From
that
the 99.
94, you said 11 November 5th. Yes,
11/5, correct,
yes, it was 94, correct.
right. And then the last one that you testified you had was on 11/14, is that correct?
Yes,
And that was, again, a little over a week later than the 11/5, and that is lower than that. In fact, that was 91. Is that correct?
that's correct. Yep.
So other than this leap to 822, everything has been going down except for that one little blip in November. Is that correct?
That's what the report showed. Yes.
Yeah. Or just.
Okay, thank you. Hmm.
To be a fair statement. Zarneski, Z, I forget it, oh, hoping I'm pronouncing your name correctly.
That's fine.
That, and I know you can't comment or you don't have any expertise in the evaluation of the tests, but mistakes do happen when testing for drugs, alcohol, or anything else. Is that correct?
I just have the records, what they show. I would have to have the toxicologist weigh in on the determination on that.
And you're not a toxicologist, I understand.
No, I'm not.
So all you do is, and again, I'm not degrading what you do. All you do is you collect the paperwork.
Okay, hold on, let's do this. Let's go off the record. Council, let me see both of you in chambers. Okay. Let's go off the record. What's that?
I'm ready.
Okay, we are on the record in the matter, we're recalling the matter of Dorian Jones, 25578. Both counsels present. Court had an in-chambers conference with counsel. And so counsels agreed that we're going to adjourn this matter to January 14th so that we can have the toxicologist and the individual that collected the sample with the testing facility present. So that there can be some additional questions that Ms. Z is not able to answer given her her role in the process. So let's adjourn that to what time? 11-ish?
In 11:30.
Okay, 11:30.
Thank you, Your Honor.
Okay,
Thank you, Your Honor. Thank you.
all right, thank you. Thank you so very much, ma'am.
Thank
Have a
you.
good holiday.
You too. Thank you.
Let's go on the record in the matter of the city of Wyandotte the state of Michigan versus George De La Cerda, 241128.
Good afternoon, Your Honor. Roman Fitzai on behalf of Mr. De La Cerda.
Thank you. And Mr. De La Cerda, your name for the record, please.
George De La Cerda.
All right, thank you. And thank you for dressing appropriately for court. And Mr. De La Cerda is on probation with this court. And it's alleged that Mr. De La Cerda was convicted of trespassing in Florida on May 24th. Did not report this to probation. Tested positive for alcohol September 29th, October 16th, October 20th. And your client is currently on probation for operating while physically impaired. Counsel?
Your Honor, we set the matter over for today to have a hearing on this matter. I've spoken with Mr. De La Cerda, and he's willing to enter a plea at this point to the violations with an opportunity. Hopefully, we can explain the nature of his actions.
Please raise your right hand, sir. Do you solemnly swear from the testimony you're about to give in this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right. And sir, you heard the allegations, correct?
Correct.
And as to the probation violation allegations, how do you plead?
Guilty, Your Honor.
And you've gone over your advice of rights with your attorney, correct?
Correct.
And you understand all of those rights.
Yes, sir.
You also understand, sir, the possible penalty as a result of your plea.
Yes, Your Honor.
And then the recommendation in this matter is for probation to be revoked. Case closed without improvement. Pay a $50 probation violation, 45 days jail to be tethered in treatment. You understand that's the recommendation.
Yes, Your Honor.
You also understand that this court could follow that recommendation in whole, in part, or not at all. Do you understand that?
Yes, Your Honor.
Knowing all of that, do you want to continue with your plea?
Yes, Your Honor.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No, Your Honor.
Any immigration issues?
No.
Counsel, if you can please voir dire your client.
Okay. Mr. De La Cerda, on or about 9/29/2025, you tested positive for alcohol. Is that correct?
That's correct.
There was also a test on 10/16/2025, which also tested positive for alcohol, correct?
That's correct.
And there was another violation on 10/20/2025.
Correct.
And they were all alcohol related.
Yes.
And what was the nature of your testing that you were ordered to do as part of your probation?
I'm sorry?
How were you being tested in accordance with your probationary order?
I was going to DNA to go to get drug and alcohol tested.
Okay. And as a result of those tests, you got 3 positives, correct?
Correct.
All right. And also there was a conviction in the state of Florida on 5/23/2025. Were you convicted of the offense of trespass in Florida?
Yes.
And did you fail to notify your probation officer of the offense?
Yes.
Did you try, in fact, to contact your probation officer regarding that offense?
At the time I did, but I didn't have service where I was at in Florida. I was in Clearwater, Florida.
Okay, when you say service, was that phone service?
Yeah, yes.
Okay, all right. And with respect to these violations, you're entering a plea of guilty because you believe you are guilty, correct?
Correct.
All right, thank you. I have no further questions.
All right, the court, will accept your plea as knowing, voluntary, and factually accurate. The court, based upon your plea of guilty, indicate technical violations 2 through 4. And what is it you'd like the court to know, counsel?
Well, Your Honor, Mr. De La Cerda, when we were last in court ordered an alcohol tether, and he immediately got one installed that day. He's not had any violations. He works 40 to 60 hours a week. And we're requesting that he be allowed to stay on his alcohol tether and or for him to engage in some alcohol outpatient treatment. At the time of his alcohol violations, he had a death in the family. And although it's no excuse to turn to alcohol to help deal with it, he unfortunately dealt with it in that fashion. He realizes that that was wrong. He's willing to stay alcohol free. He's willing to continue with the alcohol tether and or whatever other requirements the court is willing to impose. He has paid all of his fines and costs. Otherwise, it's indicated he had not paid them according to the initial petition on his violation, but he has paid everything in full. And we would just ask the court to allow him to continue with a alcohol tether. He does support his parents also through his work. That's part of the reason why he works as many hours as he does. His parents are elderly, as I understand it. And I don't want to say he's got a lot on his plate and has to turn to alcohol, but unfortunately that was the choice he made because of the situation that he was under at the time. He's committed to staying alcohol free. He is totally committed to keeping his alcohol tether on. And I would ask the court to consider that.
Sir, how'd you get here today?
I had my girlfriend in the back drive me here.
Okay. And so, sir, you had permission to go to Florida, correct?
I did, Your Honor.
And so, while this court gave you permission to go to Florida, you apparently violated the law and were charged with trespassing, correct? And then not only did you violate the law and then you didn't tell the court, even your probation officer, but then you were convicted of violating the law. And you failed to tell anybody. One of the conditions of probation was you're not to violate any criminal law.
Correct.
I mean, I guess technically I say, I say of any unit of government. So, sir, not only did you violate the law, you were convicted of it. And then you failed to disclose that.
Yes.
And then when did your family member pass away, sir?
It passed away in the beginning of September. It was my grandmother. She was actually one of my closest family members around here because I'm from Mexico originally. So I only had my mother, my father, my younger brother, and my older sister, which currently lives in Georgia. But my grandmother was a big part of like who I had here in the United States for a very long time. So,
and sir, that's understandable.
Yes.
But did my order of probation say that you're not to possess or consume any alcohol or drugs unless there's a family member's passing?
Yes, Your Honor.
That's what I said? That's what my condition was?
I mean, no, it's not what it said, but I understand that.
And then it wasn't even the beginning of September. It was September 29th you tested positive, October 16th, and October 20th at high levels. And let's not forget, your alcohol level at the time of conviction in this matter was a 0.185. And this court ordered mandatory jail for any probation violation. And something tells me, did you request an early discharge, sir?
Did I?
Yes.
No, the lawyer I had beforehand, basically had me, at first he sentenced me to 2 years, but he had it down to if I got done with everything within the first year.
Right, so had you
I never
dismissed, it wouldn't be dismissed.
Well, that's what was recommended. I never.
No, it was never recommended that the matter be dismissed. Because you were charged with operating while intoxicated second offense. It was reduced to operating while intoxicated first offense. So I think I misstated when I said operating while impaired, because operating while intoxicated first offense. And so I sentenced you to 18 months probation, so you would have been eligible for early discharge upon your request at the 9-month mark. Did you make that request, sir?
I didn't
No,
personally.
okay. So, and how did your probation officer become aware of this? Did you at any point tell her, or did she inform you that she?
She informed me herself.
Right, because she probably ran your record so that to prepare you for potential discharge, and that's when it popped up. Do you recall this court indicating mandatory jail for any probation violation at sentencing?
I'm sorry?
Do you recall this court ordering mandatory jail for any violation at sentencing?
Yes, ma'am.
Okay, well, that's what this court's going to do. This court's going to, you have 4 violations, sir, not just 1 but 4. This court's going to adopt the recommendation. The court's going to order 45 days jail, tethered to treatment, $50 probation violation fee, revoke probation, case closed without improvement. All right, you're gonna walk out this door today, sir.
Okay. Can he grab my jacket? Just so I can have all my property for when I get out?
Well, I think that he'll meet you with it. Somebody will meet you with it over that way.
All right. Thank you, Your Honor. Thank you for
Thank you,
allowing,
Michael.
accommodating me to participate via Zoom.
Feel better. You're welcome. Feel better.
Thank you.
Yes, it's the welcome to bring in one bag to for both pieces of my phone.
Your head has to be off, young man. I'm sorry, ma'am, whoever that is with you, the hat has to be off. Not the mask, the hat. Thank you. The mask can stay on if you prefer, but not the hat. Let's go on the record in the matter of the City of Wyandotte versus Michael Quinn. All right, Michael Jason Quinn is 251289. Michael Jack Quinn is 25W66992 A and B, 25W96925, 25W97258, 25W97879 A and B, 25W97908 A and B.
Your Honor, John Goldwasser, P30758, on behalf of Michael Jason Quinn. Mr. Jason Quinn, Michael Jason Quinn is present court to my far left. Also present is Michael Jack Quinn, whom I believe. As the court is aware, I'm representing Mr. Jason Quinn on these matters, but also been present during the last number of hearings.
All right, thank you. And so, Michael Jason Quinn, your name for the record, please.
Michael Jason Quinn.
Okay. And Michael Jack Quinn, your name for the record, please.
Michael Jack Quinn.
Okay, keep your hands out of your pockets, please. And so what's happening today?
We're here for the sentencing on Mr. Michael, Jason Quinn, there have been a number of.
Who are you? Come on up, Mr. McFeeters. Oh, the other matter is dismissed. If Mr. Anderson, if two, the other is dismissed and read in. We will go on the record in the matters 25 CM 230, 25 TR 916, 917, 918, State of Wisconsin versus Nicholas McFeeters. The state appears through Assistant District Attorney Jose Vila in person. Mr. McFeeters appears in person without counsel. We're set here today in these matters for initial appearances. They're tickets for seatbelt violation, non-registration of vehicle, operating without insurance, one charge, criminal charge of possession of THC, one of drug paraphernalia, one with operating while revoked. Is there an offer that can be presented today?
Yes, Your Honor. The offer is for him to get his license and we dismiss everything, or he can plead to the OAR for a fine.
All right. So, Mr. McFeeters, the offer that they're presenting is if you want to go ahead and get your license, if you think you have the ability to do that, you'll get your license and everything is going to be dismissed. If you don't get your license and you just want to take care of the matter, they're asking that you plead to that operating while revoked for costs only, then everything else would be dismissed.
I would like to just plead for costs only.
Okay, so you want to plead for the operating while revoked?
Operating while revoked, yes.
Okay, and so do you understand that you would have the right to have an attorney?
I understand.
And you wish to represent yourself here today?
Just so I understand that the marijuana charge, the possession charge, all that goes away?
Yes.
Then yeah, I would like to just represent myself and just take care of it today.
Okay, how old are you?
I'm 37 years old.
Can you read, write? Do you understand the English language?
Yes, ma'am.
Any drugs, alcohol, or other medications in the last 24 hours?
No, ma'am.
Any mental illnesses or disorders?
I have PTSD.
Now, with that PTSD, are you in a place right now where you're calm and you understand what's going on?
Yes, ma'am.
Okay.
Yes, ma'am.
Now, do you understand you would have the right to go to trial with this? You would have the right to have an attorney, and the attorney could cross-examine the state's witnesses or call witnesses to testify for you. You would have the right to testify on your own behalf or remain silent and not have your silence used against you. You would have the right to have a jury trial where 12 of your peers would need to reach a unanimous decision as to a guilty verdict or find you not guilty. And you would have the right to have the state prove your guilt beyond a reasonable doubt. Do you understand all of those rights you're giving up here today?
I do understand, Your Honor. I was driving and I was in possession, so I'm just going to take care of it.
I appreciate the honesty. So do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, Your Honor.
Do you understand the state would have to prove on or around October 27, 2025 in Burnett County, Wisconsin, you operated a motor vehicle on a highway or roadway of this county and state without with having a revoked operator's license?
I understand.
Do you understand maximum penalty could be a fine of up to $2,500 or 1 year in the county jail or both?
I understand.
Do you understand there's an offer here for costs only, but I'm not bound to follow that. I could sentence you to the maximum penalty if I thought it was warranted.
Yes, I understand.
And so you wish to proceed. Do you have any questions for the court before we proceed?
No, Your Honor.
So you're admitting today you did in fact do that?
Yes.
And
yes.
you're guilty of that charge?
I am guilty. I'm pleading guilty. I'm not going to fight it. Why waste time?
Appreciate that. Okay. Anyone threaten you or promise you anything for you to do that?
No, ma'am.
You're doing so freely and intelligently and voluntarily?
Yes, ma'am.
Then as to count 3, operating a motor vehicle while revoked, how do you wish to plead?
Guilty, Your Honor.
The court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept that plea of guilt. Based on that, I will find you guilty of count 3, operating motor vehicle while revoked. The other charges in that matter and the other open ticket files will be dismissed and read in for purposes of sentencing. A judgment will be entered today. Argument, Mr. Vila.
Thank you, Your Honor. Mr. McFeeters is here accepting responsibility today. Given that this is a low-level offense, I believe court cost is appropriate. Thank you.
You want to tell me anything, say anything, Mr. McFeeters?
It's McFeeters.
McFeeters, sorry.
Yeah. Nope, you're okay. Nope, no, I got nothing else to say on that.
All right. This is a low-level offense. There are other things attached to it. I'm just going to tell you, make sure you have your insurance, make sure that the vehicle's registered. Wear your seatbelt, sir.
Yes, ma'am.
Please, wear
Yes,
your
ma'am.
seatbelt. I want to make sure you're safe. So do those things, and I have to give you the warning. Also, THC is not legal in Wisconsin in any shape, way, or form. Okay, so those are the warnings. I think that.
Could I ask you one question on that, ma'am?
Yes.
Why is it I can go to Grantsburg and buy THCA products, but not regular THC products?
That is not a question for me to answer, and that's more a question for the state to answer. However, it's really a question for the legislature to answer.
Understood, ma'am. Understood.
It's a very confusing thing.
It
quite
is.
honestly.
It very is.
Even being legal minds, it's a confusing thing.
Okay.
So
I can accept that answer.
So I'm sorry, I don't have a better explanation.
You're all good.
So what I'm gonna do here today, it's cost only. Since you're pleading guilty, you're accepting responsibility, I'm only gonna assess $150 instead of $330.50.
Thank you, Your Honor.
I'm
Thank
gonna
you.
waive that rest because you're taking the responsibility, you're being accountable. Do you have the ability to pay that today?
I do not. Could I get 30 days to pay it, please?
30 days to pay. I do have to give you the warning. If you don't pay in 30 days, a civil judgment will be entered against you, and I'll issue a warrant. You could sit up to 6 months in jail. So make sure you get that paid, okay?
Yes, ma'am.
All right.
Where would I go to pay that?
The clerk's office right around the corner here.
Thank you
Okay.
very much.
All right. Good job. Thank you. We're adjourned.
Do I need to sign any paperwork? or
You're
anything?
good to go.
Thank you, ma'am.
Oh, I'm sorry. You did plead to the charge. So I do need your DNA. So what you're going to need to do,
It is already on file from a
You-
previous case.
I know you still have to take a sheet of paper to the sheriff's department and turn it in. If they
Okay.
need it, they'll say, we need it. If they don't, they'll say you're good to go.
So I can just stop by downstairs on the way out?
Yes.
All
So
right.
come get the sheet of paper. That's what you're going to bring to the sheriff's department. And then you know where to pay your 150 when you have the money in 30 days. Okay? Thank you. We will go on the record in the matters 24 CF 235 and 25 CM 63, State of Wisconsin versus Margarito Tiarina. Appearances are Mr. Tiarina appears in person with his counsel Daniel Chapman. We have the state through Assistant District Attorney Jose Vila. We will go on the record in the matter 24 CF 235, 25 CM 63, State of Wisconsin versus Margarito Tiarina. The state appears through District Attorney Aaron Marco as special prosecutor in this matter. He's appearing by video conferencing in Washburn. We have Mr. Tiarina in person with his counsel Daniel Chapman. We're set today in these matters for plea and sentencing. Mr. Chapman, can you please recite the agreement for the record?
Your Honor, Mr. Tiarina has completed a 45-day inpatient treatment program prior to the plea as envisioned by the offer. In exchange, the state has agreed to amend count 1 in 24 CF 235 to misdemeanor possession of amphetamine. And Mr. Tiarina will be pleading to that and to disorderly conduct in 25 CM 63. There is also an uncharged bail jumping, which I believe was for being present in a bar but not drinking, that the state has agreed not to charge. And there's a joint recommendation for costs.
And that's correct, Mr. Marco?
It is, I believe, costs in this matter would be $961, if I'm correct, for one felony and one misdemeanor plea.
All right, thank you.
And he would get, I think we also agreed that he would get pre-sentence credit for the time he spent in that inpatient treatment program.
So what are the total days that he would have credit for?
It was a 45-day program, Judge. I don't have the dates handy, but
I know he was in custody for a while, at least on the first charge.
Yeah, it was like 10 days. And then October 21st to December 3rd.
That's when you were in custody?
No, that's when I was at the treatment center.
Oh, okay.
I can check, Judge. I didn't add up the dates because I wasn't expecting to consider a jail sentence today, but I will have the number handy.
Okay, thank you. Formal motion to amend count 1 in 24 CF 235 to an amphetamine.
So moved, I believe it's statute 961.41 sub 3G sub D, an unclassified misdemeanor punishable by a $5,000 fine and 1 year in the county jail, or both.
Thank you, Mr. Marco. I have in front of me a plea questionnaire waiver of rights form. Do you recognize the document?
Yes, ma'am.
Did your attorney thoroughly go over this document with you,
Yes, ma'am.
word for word?
Yes, ma'am.
And attached to that document are the list of the elements the state would have to prove, as well as the maximum penalties you face. Did he thoroughly go over those with you?
Yes, ma'am.
Did you sign this document?
Yes, ma'am.
Did your attorney thoroughly go over your constitutional rights with you?
Yes, ma'am. He did.
You understand them completely?
Yes, ma'am. I do.
Do you need me to go over those rights with you in any more detail?
I do not, ma'am.
You read, you write, you understand English,
Yes, ma'am.
and nothing's interfering with your ability to comprehend or understand what's going on here today?
No, ma'am.
You understand that if you're not a citizen of the United States, your plea could result in your deportation?
Yes, ma'am.
Do you understand the state would have to prove for 24 CF 231 amended count 1 possession of amphetamine on or around September 15th, 2024, you possessed a substance. The substance was a controlled substance in an amphetamine classification, and you knew or believed that substance was a controlled substance in an amphetamine classification. Do you understand what the state would have to prove?
Yes, ma'am.
You understand maximum possible penalty could be a fine of up to $5,000 or 1 year in the county jail, or both?
Yes, ma'am.
You also understand as to 25 CM 63, the state would have to prove on or around April 5th, 2025, while in a private place you engaged in boisterous, unreasonably loud, or otherwise disorderly conduct that tended to provoke a disturbance. Do you understand what the state would have to prove?
Yes, ma'am.
Do you understand the maximum possible penalty could be a fine of up to $1,000 or imprisonment of up to 90 days of jail, or both?
Yes, ma'am.
You understand there's a recommendation for costs only, but I'm not bound to follow that.
Yes, ma'am. I am aware.
Sentence you to any sentence I feel is appropriate, even up to the maximum penalties. Do you understand that?
Yes, ma'am.
Do you still wish to proceed and enter guilty pleas?
Yes, ma'am.
Did you go over the criminal complaints with your attorney
I did, ma'am.
and the facts that are alleged in those complaints?
Yes, ma'am.
For the most part, are those facts accurate?
Yes, ma'am.
Are you admitting here today you in fact did possess a substance in an amphetamine classification,
Yes, ma'am.
and you did engage in boisterous or unreasonably loud or disorderly conduct?
Yes, ma'am.
Are you pleading guilty because you're guilty of these offenses?
Yes, ma'am.
Mr. Chapman, may the court use the probable cause sections of the criminal complaints to find a factual basis?
Yes, Your Honor.
Has anyone made any threats or any promises to you for you to plead guilty to these charges?
No, ma'am.
You're doing so freely and intelligently, telling the court you fully understand what you're doing,
I do freely understand
and you're doing so voluntarily.
and doing so voluntarily.
Are you satisfied with your attorney's services?
Yes, ma'am, I am.
Has he done a good job?
Yes, ma'am, he has.
Any questions for the court or for your attorney before I proceed?
No questions, ma'am.
Any objection to Mr. Marco appearing by video conferencing?
No objections.
Then as to the amended count 1 in 24 CF 235 amphetamine, how do you wish to plead?
Plead guilty.
25 CM 63 disorderly conduct, how do you wish to plead?
I plead guilty.
Court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 2 charges. The other charge will be dismissed and read in for purposes of sentencing. The other charges, judgment of conviction will be entered today. Argument, Mr. Marco?
I do believe this is a reasonable resolution, but it also does have a unique factor in that before the case was assigned to me, District Attorney for Burnett County, Kevin Schmidt, and Mr. Chapman had been in negotiations, and Attorney Schmidt had extended an offer to Attorney Chapman that if Mr. Tijerina had completed inpatient treatment and gone through the steps and received services that he would have received on probation anyways, that there would not be a probation recommendation and that it would be reduced to the amphetamine. Now, he did receive the
For some reason, your microphone it's not really working very well.
I'm sorry, if I get closer, does that make it worse or better?
It's not really helping. It's like you're talking underwater with bubbles.
I have found that turning off the video when I'm in a bad reception area helps sometimes.
He's in their system.
Oh,
Well, I'm actually on my laptop in the courtroom. So did that get any better?
That got much better. How are you talking through the microphone at the courtroom with your laptop?
I don't know. I don't understand this technology.
Okay, never mind. Okay, go ahead. We can hear you much better now.
Okay, so what I was saying was that Attorney Schmidt had extended an offer based on negotiations he had with Attorney Chapman prior to me being assigned to the case as a special prosecutor. I believe I'm obligated to honor that offer, although Mr. Tijerina did get the disorderly conduct charge, which theoretically could relieve the state from that obligation. As the court is aware, it was an argument with his brother that was kind of a family type of situation. I didn't feel it was something that was significant enough for him to lose the benefit of this, nor was it something that was significant enough for the community to lose the benefit of him going through treatment and hopefully gaining some sobriety and disengaging from the criminal justice system. So looked at as a whole, I do believe that it was a reasonable obligation. It was something that Attorney Schmidt had entered into that I'm honoring, and Mr. Tijerina has followed through. As took him a long time, but he did follow through with everything, and I believe he deserves the benefit of that. Thank you.
Thank you. Mr. Chapman.
Your Honor, prior to this case, other than an OAR in 2023, Mr. Tijerina's last criminal conviction was in 2014, and I don't believe he has any other drug cases, at least not in Wisconsin. This case involved him being stopped for driving without a license. The cops smelled marijuana, and they searched the car and found some personal use stuff, honestly, mostly in his girlfriend's purse. Both of them admitted to using, and he has completed inpatient treatment. I think Mr. Tijerina enjoys being sober, and he's looking forward to staying sober. And I think the public has been protected by the fact that he's already complied with the treatment in this case. I'd ask you to follow the recommendation. And in addition to the treatment, I also see that he spent 12 days in custody in April and 2 days in September of last year.
Okay. Mr. Tijerina, is there anything that you would like to say?
I'm glad that I went to the treatment center. I'm glad where my path is going now, because it's I should have done it a long time ago. So I feel fantastic.
Well, I am glad to hear that, Mr. Tijerina. I was aware of your last conviction, and I think at the last conviction with that OAR, I believe you had stated that you hadn't had any convictions or issues for many, many, many years.
Mm-hmm.
I hope you've mended fences with Jose.
Yeah, we're cool.
That's good. I think that this is appropriate. You went through treatment 45 days. That's a long period of time. I am going to order 75 days of jail per count, time served. You've already sat the time. You're going to get the credit for it. The state agrees to have that 45 days be included as jail time. So 75 days of jail per count. I'm going to assess $443 in fines and fees for the misdemeanor, $518 for the felony. You have 20 days.
I apologize. I misspoke. That was felony was reduced to a misdemeanor. So
that's right. Never mind.
$6 total.
So $886. So $443 per count. And you have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. I need your DNA. When you're done here, you're going to go to the sheriff's department and see if they need that. If they do, they'll swab you. If they don't, they'll send you on your way. You have the right to request it be expunged through a written letter to the Department of Justice, okay?
Thank you.
When you're done here, come up here and get the white piece of paper to bring it to the sheriff's department. You're good to go. Do you need a payment plan?
I do, ma'am.
Okay, so I'm going to say $100 per month. The first payment is due by the end of December, $100 thereafter until paid off in full, okay?
Yes, ma'am.
If you fail to pay it off in full, not only will the court enter a civil judgment against you, because you're always going to owe it, but I will issue a warrant. You could sit up to 6 months in jail, okay?
Understood.
Right. Thank you.
Thank you, Your Honor.
We are adjourned.
Thank you, Judge.
Thank you.
Okay, next matter is number 6 on the calendar, Daryl McWilliams.
Good morning, Your Honor.
Good morning, Mr. McWilliams. Let me go ahead and pull up your case in the
I
computer.
apologize for being in bed. I'm not feeling well, but I'm here with a good appearance in the background, so.
Okay, well, it's not inappropriate, so that's fine.
Did you receive my motions to dismiss both cases? First question.
I believe I've got a copy of that in the file. Let me go ahead and pull up some papers here from the court file. One moment.
Yeah, there should be 2 cases on today. And they both have motions for dismissal and all that filed into them.
Do we have 2 cases on for, oh yeah, I see. Number 6 and 7. Okay, got it.
Yeah, you should have 5A0490039 and 5A0424973.
Okay, I do see your motion to globalize and to dismiss.
Yeah,
Please stand by while I take a chance to look that over.
Go ahead.
Okay, Mr. McWilliams, I have reviewed your motions, and your motion to dismiss the cases against you is denied. Do you have any other argument?
Yes, I would like to set this matter over because there's a case currently ongoing, and I will cite that for you. It's Master Sergeant Charles Fields, my father, case number 25201-292-08 in the Superior Court. It has jurisdictional authority over this matter. It is currently handling ex parte motions of stay of relief. I also have other criminal cases where I have an attorney who's motioning the constitutionality of the order plus getting a sound expert. I would ask to defer today's hearing to a later date to allow those motions and orders of Superior Court to proceed and allow my attorney the opportunity to have the prosecutor removed as well as argue the constitutionality of the legal ordinance modification. Just so you know, Your Honor, I responsibly in the beginning of the year took accountability for a charge of playing music because I DJ, and a prosecutorial agreement was made, and then suddenly months later they illegally modified the law without applying to the Department of Ecology pursuant to RCW. So there's a lot of moving parts right now, and rather than argue today or bring witnesses, if you're going to deny my order on the face of, I would ask that you allow the Superior Court time for the case that I cited to make a ruling over its jurisdiction in this matter, also allowing my time for my criminal attorney to finish her filings so that I may copy and apply them into this case as they have revolving facts and similarities as well as a question of the constitutionality of the law. So I would ask that this, based on her presumption that the constitutionality argument will take 1 to 2 weeks to get in and then heard, I would ask that this be set over for a month, at which point I will bring witnesses and I will supply the court with more evidence, including any other filings or orders if the Superior Court chooses to dismiss this on the merits of which we motioned.
So I do find that both of the cases that are pending on this morning's docket were filed and notice was mailed. Well, in one case earlier in September, and in the other case was filed towards the end of September, and the notice was mailed on October 1st.
Yes, but there's been an ongoing barrage of police.
Sir, I'm speaking. It's currently December 10th. I do find that that's adequate time for you to have prepared your defense. I also noticed that your attorney is not appearing on your behalf today. You may have an attorney in other cases, but it appears you don't have counsel in this case. I've considered the argument that you've raised, and I'd like to, at this point in time, understand if I'd like to hear if you have any further argument or testimony that you'd like to offer.
Yes, the citations that are before you lack police training because they were reading in DBC and not DBA, and the law is specifically cited as DBA as the measurement, as my expert witness will testify as well. So the two citations before you today, sir, were unlawfully measured in DBC and not accurately to DBA. Myself, Charles Fields, and Logan Fields, who I can get mustered up right now for testimony, were there when we tested sound decibels, and we have a scientific measurement. I master all my sounds through a software called Platinum Notes. So they're all measured to negative 11.5 decibels. So when the board is set for sound, each song is exactly the same. And I've also built a $7,000 acoustic wall since the first charge. I've taken steps and liberties to ensure that I'm not a disturbance. However, the cases before you in these two violation codes, I believe one of them was for violating the decibel readings. However, the officers have already admitted on camera to me and on the record that they were reading in DBC, which is a different compression and more sensitive and not reflective, as the law states, of DBA. And I believe the second one was for motor vehicle noises or sirens and horns, which doesn't apply to this situation. So it's a illegal law that doesn't apply to what was going on. Unless I'm standing wrong, there's a lot of them. These both could be the ones where they just read in DBC. So with that said, we have a problem because the law states DBA. So the ones before you, I believe, are unconstitutional and inaccurate based on the evidence. But I am a disabled, vulnerable adult, and I've been subjected to violent crimes and abuses over the past 60 days. There are multiple protection orders granted for me as a vulnerable adult. That's why I would justify to you, Your Honor, the continuance based on the special circumstances, not your review of the calendar. But I'm happy to cite every case right now to you to show you that I've been busy protecting me and the custodial rights of my minor children and my adopted adult, vulnerable adult son, Logan Fields, who also participates in the music. The music is for therapy purposes, of which my doctors will testify. I made a prosecutorial agreement and I stayed within those sound decibels, but unfortunately the officers in the beginning were reading them in DBC. Even Officer Yeager himself shows his DBC reader beside mine in a video, which I didn't have time to get before you because my life has been in danger. But in that video, he shows, oh man, we have been reading in DBC and not DBA, because showing even on my porch, I'm within those EDNA Class A residency levels, which is between 7 a.m. and 10 p.m. You could be 55 decibels and under. You can exceed decibel limits for 15, 10, and 5-minute segments by certain amounts of decibels. In this case, I would be testing scientific equipment like Serum 2 presets. Sometimes when you try a preset, it fires off louder out of the decibels when it's a DAW plugin, which is the digital audio workstation. So no effort or angle of any of my music has ever been meant to disturb or annoy anybody. But I do believe in the two citations you have that they were decibel reading oriented. And at that time in training, those officers were reading in DBC and not DBA. And I was following the prosecutorial agreement at all times. What we've run into now is several more charges which are being challenged because after the prosecutorial deal, they then modified the law without applying to the Department of Ecology and made it where the neighbors have discretion. And since then, they've been abusing it, up to 9 charges now. And I've had to get protective orders from them from trying to run me over with their truck. They're making threats against me. They're slandering and libeling me. There's an open civil case against them, as well as the Master Sergeant Fields versus City of Castle Rock. They have retained a really big law firm. And right now we have filed motions even today in court for ex parte to address this case among the other several noise violations. So I would ask, based on the evidence alone within your police report, that the officers lack training and knowledgeable understanding of decibel measurements and we're not accurately reading and reflecting that. I know this because I volunteer a lot of my time with churches for LED walls, stage, and their concert developments. And for the audience, we have to keep it below 92 decibels for a certain amount of time exposure or it could damage hearing. I'm very knowledgeable in measuring decibels, and I've taken every step to make sure I'm not violating the law since I first agreed to a prosecutorial deal in which I accepted guilt without even having an attorney. But now that the city has taken to egregious conduct, we are now motioning for a special prosecutor because even prosecutor Christopher Eastwood said he's out for my blood, and he said it in front of the mayor or the Grimm Law Group when they were representing me, until a neighbor broke into my house and tried to assault me, and now the Grimm Law Group represents her. There's a lot of conflict and overlapping facts, and it all originates with the city and improper decibel readings, trainings, and legal modifications to the law. So while these things are ongoing, I would ask that if you read the police report, you'll notice that this is a decibel measurement training lacking, that they were coordinating at that time in the wrong measurements, because any other time after that, once they went from DBC to DBA, the officers acknowledged that I was within the sound limits. And I have what I call the cop line on my Flex 10. It's a DJ controller board, and I have it marked so that way I know I'm always within the decibel limits, even after installing a $7,000 acoustic wall. I've made every effort to make accommodations, not only for my needs as a vulnerable adult defined by Washington state and federal laws to be able to play sound for therapy purposes, but I've tried to create a safe environment for my community. But the neighbors have taken to making false allegations that I have a gun and I'm pointing at them, and extreme egregious acts that I am a felon as a felon and I cannot have guns. So I am objecting to these actions that are being done to me. So right now there's kind of a lot of things revolving. That's why I asked in my motion to globalize the cases, because there's training aspects to address, there's laws and ordinances to address, and more importantly, there was no motor vehicles, sirens, horns, or anything like such taking place, like further citations. So I would ask this court dismiss this on the basis that the officers acknowledged that they were reading in the wrong decibel compression.
Okay,
format.
thank you for summarizing your motion, Mr. McWilliams. Your motion to dismiss is denied based upon the evidence that is set forth in the officer's report on the case ending in 4973, as well as the case ending in 0039. The court does admit into evidence both of those officer reports, and based upon that evidence, I will find the violations committed on
Have you, before you say that, have you find those violations so I can appeal them?
Sir, you absolutely can appeal my ruling.
Yeah, but give me a
issue with
reason.
that at all.
Don't be a baby about it.
No, there's no issue, sir. There's no issue with that at all. You contact the clerk's office. You can file your notice of appeal. On case number 4973, the violation amount is $103. And on the case ending in 0039, the violation amount is $257. That'll be the court's order for today.
What evidence are you citing as the basis against my actual legitimate legal motion? You're saying the
evidence is what the evidence is what I just cited to, which is the officer's reports in both matters which the court has admitted into evidence. So in response to your question, that is the evidence against you.
Sworn officers that are being sued in a federal lawsuit for face value when they've been targeting and attacking me.
That constitutes the evidence against you today. That's going to be the court's order. This concludes your matters.
That's all right. But wait, that takes us
I'd like to thank you. I'd like to thank you for, sir.
You shut the fuck up and let me talk for a moment.
Hey, don't speak that way in court.
What are you going to do? Throw me in jail?
Well, if you were here, it might be an
I bet
option.
you wish you could. You know what? Give me a real reason. A one-sided
Sir,
police report.
sir,
A
you're-
judge has even said a
Sir,
one-sided
I don't want to
police
have to
report
find you in
is not
contempt,
evident.
okay?
For
I
what,
don't want to have
being
to find you in
disabled and under
contempt.
duress?
This concludes your matter for today.
My First
You're
Amendment
free to
rights?
disconnect at this time.
Yeah,
Thank
you're a
you.
coward. You're a coward. You're a coward. Remember that.
Okay, well.
So, I will just hypothesize that, you know, things like bench warrants don't have to be done right in the moment on the record for everybody to see. He could just politely write a note in the background and say, hey, this one gets a bench warrant. Let's make sure that we send somebody out to say hi and say hi to it. But ladies and gentlemen, that's all we got for tonight. I am your Lone Wolf Usul, and I am going to use punctuation in my sentence. Although I was tempted to try and not do that. I just don't even think I could do that if I wanted. But ladies and gentlemen, come on by here every night. 8 p.m. Central Time, 9 p.m. Eastern Time. I'll have more stuff. Some of the best cases of the day, hopefully. Thank you all for coming out. Thank you for everybody who hung out with us tonight. It's been an amazing chat. We had a great turnout. We're not going anywhere special tonight. It's over. It's over. We're done. The dogs are ready to go out. The cat's mad. And I have had fun. So ladies and gentlemen, thank you very much. It's been a wonderful night. We'll see you next time. I'm your humble Lone Wolf Usul. I'm your curator. I'm your host for these here proceedings. And I am out. See you later. We all lost brain cells together, Kia North. You're not alone. You know. God. Good night, folks.